Hello, everyone. Welcome in. Let's get right to it. There are a few core issues that I think the state will need to hammer home at oral argument, and these are very, very important in my opinion. Those issues summarized are as follows. Number one, no incriminating statements were made by the defendant. Number two, the exception to 11504 applies in its totality to the medical records and the conversations had between Trevizo and medical providers. And number three, should we fail on Miranda, it must be argued that at the very least, witness and medical provider statements in front of police shall not be suppressed. If they want to suppress the defendant's statements in front of police, fine. But there are no grounds to suppress witness Rosa or the doctor or charge nurse HT's statements. And then I have some clips coming up. And as we'll see in these clips, they're short, very, very short little clips here. We will see how these arguments and these issues can and will be pressed upon both sides. And in my opinion, the defense more than the state. Now, in this clip, we're basically going to be talking about a DNA issue and how a certain district in New Mexico goes about getting DNA without a warrant, and it's rather put under a case management system. This is interesting, and it's as close of some sort of evidentiary argument in a criminal matter that I could find with these justices as of recently to give us a good idea as to something we may see here coming up on September 4th. So keeping the evidence, the issues, the arguments in mind that we know for Team Trevizo, let's see this first clip of oral argument that we can begin to learn from and be prepared as to what we may be seeing here soon.
So we think that under our Constitution, the severance of the magistrate court's jurisdiction over a case when it's transferred to the district court.
Can a Metro Court judge sign a felony warrant?
Yes.
Now, jurisdiction to sign a felony warrant is different from jurisdiction to try a felony case. Is that correct?
They're very closely related. And let me say that there is, I think you're pointing to Sadlowski, which is a federal case that makes a distinction between the trial jurisdiction of a court of limited jurisdiction.
Felt like that was a good place to start because right off the bat, you basically see the Chief Justice push back on the questions and you see an answer come from the appellee with a case that they believe the justice may be thinking about or maybe just helps their case at that point. And this is exactly what you want to do when pushed back on by one of the justices. And I believe we may see some of this same pushback just like this. And that is because the defense has gone about the route of claiming that baby Alex is a stillborn and that this is a criminalized pregnancy outcome rather than a murder in a murder investigation. The reason they're doing that is to hopefully allow some sort of pulling at the heartstrings or the political landscape of the times that we're in and the justices that will be hearing this to potentially see this as something other than what it actually is, in my opinion. And that's based on the facts that we have. When you see the arguments that the defense has put forth, it really starts to shut down their avenues. The defense will be relying on the Supreme Court believing that this is some new or novel issue that hasn't been discussed and decided many times over in New Mexico. And that's why you see them heavily implying that there is an issue as to the nature of the police and doctor's relationship and how they entered the room to, quote unquote, blocking Alexee from leaving the hospital room. All these things are being framed in a way to hopefully build the idea of custody, collusion, coercion between the police and the doctor to make the doctor rise to the level of some sort of state actor and meet the threshold that Alexee wouldn't reasonably be able to think she was free to leave and would reasonably believe that she's in custody despite not having been told anything of the sort. So the example, the appellee in the clip was quick. He pulled that case out and responded rather quickly, but let's see if the arguments continue to uphold despite more and more pushback in this next clip.
Constitutional
So
powers and authority, I think that's different.
So your problem isn't with the fact that they didn't do a motion for standards as opposed to a warrant. It's simply that the Metro judge signed the warrant as opposed to some district judge somewhere else.
Well, I mean, these are kind of related questions. I mean, the district court judge wanted the motion for standards
Yes.
for her.
Yes.
Presumably, the other district courts judges would know that as well, and they would communicate it among
But
themselves.
you just
so
said
can
that they
decide-
could sign a warrant. You said any district court judge
Yeah,
could
they can
sign a warrant
yes,
during the pendency of the felony case, which is different than the process of filing a motion for standards.
Yes, Your Honor, that is different.
I felt like this was a good question and a good back and forth because you can see that I believe Justice Moore there is clearly trying to get to the heart of the issue, trying to find out what's the real issue here. What are you really complaining about? What's your problem with all this? And I think a very similar line of questioning may happen to the defense in this case. Think of it this way. What if the justices aren't picking up what Gary Mitchell and Second Chair Fayerberg are throwing down? They're definitely going to have these back and forths then. There are going to have to be some hard-hitting questions or pushback to clarify about the defense's arguments. And I think they're finally going to have to account for not having a proper explanation as to why the exception to Rule 11504 applies for the initial call to police, but everything has to stop there. This is where the defense is going to have to make their arguments make sense. They may be asked something like, explain how privilege is waived enough to report the initial crime and how there is enough probable cause to get a court order for these medical records, which is very hard to do in New Mexico. But there's not enough evidence to say that medical privilege is waived based on the potential for child abuse. Explain that. Make that make sense as the defense. This is also why we keep hearing stillborn and why we see this second chair attorney being added to this case. Now, I'm not sure if they will go as far to argue that Alexee had the right to do what she did because baby Alex should not be considered a child for purposes of child abuse, rather a stillborn fetus. Now, that is a very harsh and cold argument, but it essentially cuts to what they believe based on their arguments. They believe Alexee has the right to have done whatever she did because baby Alex wasn't born alive, according to Alexee, which implies some sort of maternal privilege to decide what happens to a baby when born, which is why we may see some sort of question like the one on the screen. And we have to remember that the defense has offered nothing to prove that baby Alex is a stillborn. The Supreme Court literally cannot consider arguments not on record. They have the entire record, every piece of evidence, including the supplemental evidence because of the defense's consistent argument that baby Alex was a stillborn. The Attorney General said, you know what, let me just make sure that you guys see the autopsy and the medical examiner's testimony as to what happened to baby Alex, just so you guys are aware. An ultimate, basically, F you to the defense, being like, excuse me, put up or shut up. You need to give some evidence to back your claims. So before the question on the screen even gets asked, we may see something along the lines of, how are you even making this argument if you haven't offered any evidence? Isn't that what is supposed to be decided at trial by the jury, not by us when suppressing this evidence? We cannot suppress this based on your feelings about what happened that night. And then past that, they may want to understand the philosophy of the stillborn argument. Like, what makes a stillborn different than a live birth in regard to being placed in a trash bag? Based on that action alone, shouldn't the jury get to decide what the intent was when denying an alleged stillborn infant medical care? Or would it be the defense's position that mothers have the ultimate right to deny medical care because of a stillborn status and then dispose of the infant in a hospital nonetheless? Essentially, that is their position, is that nothing criminal happened. This was all a violation of Alexee's rights because she's allowed to do what she did because baby Alex wasn't alive. So what then is the line that we can draw when it comes to what a woman is allowed to decide based on a fetus still inside her body or a child that has come out of her body? Does the decision-making process of the other life in the room, or lack thereof, according to Team Trevizo, rest in the hands of the mother at that point? Or should that new life be granted the same ability for life, liberty, and pursuit of happiness as everyone else? Who gets to make that decision? The defense is arguing that if a woman has a baby that doesn't appear alive, they are allowed to dispose of that child however they want, and that could not be a criminal act, which would negate the exception to 11504, because there wouldn't be potential child abuse, because they wouldn't be seeing baby Alex as a child. I hope the defense doesn't outright argue that, but I pray that the Supreme Court presses them on that. We have to remember, the defense has conceded that a report needed to happen. So how are they going to reconcile a report needing to happen for potential child abuse, but the exception to the rule for the medical conversations to not also apply based on the potential child abuse? With all this, let's get into the very last clip, because I believe this one's about 2 minutes long. It's our longest clip. And then we will continue our discussion from there.
But to what end? What purpose?
Basically, it's so that the district court can manage its own case management.
No. What's the purpose of getting the swab? There's a pending case. In this case, for example,
Yes, sir.
what in the world is his swab, his DNA have to do with anything in the case?
Presumably identity is an issue, Your Honor.
They wanted fingerprints, presumably. But there's nowhere in the affidavits, either affidavit, says anything about DNA being necessary in order to assist in the investigation of the identity of the driver of the pickup truck.
That's right.
But what my question is this, is it seems like this motion for standards seems like something that everybody does in the district court. And I just don't understand why you would want to do that. It sounds like they do it in every case, and maybe I'm just being ignorant or timed out on the practice in criminal court, but I don't understand it.
Yes, Your Honor. I believe the practice, Your Honor, and I haven't done felony practice in the second district, so I'm not exactly familiar with the procedure there. I believe why they do this is that you have a case management order in place, and that under the case management order, discovery that would be obtained pursuant to a motion for body standards would be subject to disclosure much sooner than evidence that would be obtained pursuant to a search warrant.
Is that true, though? The deadlines are the deadlines, DNA scientific evidence. So regardless of where and when that evidence came, the deadlines still need to be followed. And I would be a little concerned about applying a different standard to the second versus jurisdictions that don't have a case management rule. I just don't see what prohibits the district court from enforcing those deadlines, irrespective of where or when the evidence came from.
The pushback that we saw there from the justice gives me hope for what we may see in regard to pushback in the Trevizo case specifically on the defense. This particular question asked really means that they're not even questioning the potential for obtaining DNA evidence via something other than a search warrant. They're basically asking if it's within the rules, we need to argue the rules. You're not going to get us to change the rule just because you're whining about it. You have to show why the rule itself is flawed. Now, this is the line of thinking that would be good for the state side when presenting their issues to the Supreme Court, because how the state has retrieved their evidence and argued to keep it fits the rules. These are the rules. That's why this has felt so confusing for all of us all along. And this is, again, why we see the defense frame this as a new issue, because they already know. The justices will say, we're not going to rewrite the rules for this specific incident. You have to show such a new set of facts that raises an issue of concern so large that has never been seen before by the court, never thought of, that allows them to rewrite the precedent for both Miranda and medical privilege. That is literally how the defense has described this issue to the Supreme Court. They said in the beginning of their filings, this is the first time the New Mexico Supreme Court will have made a decision about pregnancy outcome criminalization. And they're doing that because the precedent doesn't favor their side. And essentially that would mean, if you want to flip the coin to its other side, if it's not going to be considered a criminalized pregnancy outcome, wouldn't it then have to be considered child abuse, which walks Team Trevizo right in to the exception to 11504? It's been decided multiple times in the cases that we've cited here, Roper, Strauch, Lucero. All the precedent in New Mexico goes against what the defense is saying. That's why they're saying this is a brand new thing. But I don't think the justices are going to let them get away with that without pushback. We will see it, because this isn't new. This ain't new. Now, the justices may push back by way of saying, stop with this nonsense and argue the precedent and what is in evidence, not your feelings and your alibi. I really think the defense's time is coming to an end, because it's all going to come out in the wash with these justices pressing back on both sides' arguments. The logic will win. Whoever has the logic and truth on their side will come out on top. It's very possible that the issues the defense is going to use themselves in this case don't go well for them in the end, but they are trapped with what they can and can't argue. The facts are the facts, but they're not going to be able to emotionally argue their way out of this, because so far, in my opinion, they've relied on people feeling bad for Alexee, disliking the medical institution's actions, being potentially forgiving to mothers based on some sort of maternal privilege bias that they may have. But if those factors don't apply to the person hearing the defense's arguments, then the only response, and it's harsh, would be no one cares. No one cares to feel bad for Alexee. No one cares how Alexee felt that night. No one cares. The general sentiment I see from people is that they believe Alexee played judge, jury, doctor, and executioner in the bathroom. Nothing was breathing, nothing was crying. She didn't ask for help. Judge, jury, doctor, executioner, Alexee Trevizo. The defense's entire argument hinges on having to use information that they're trying to suppress. And if the Supreme Court gets a whiff of that, they are not going to appreciate trying to work around the precedent to suppress evidence only to reintroduce it, especially when the general sentiment based on the evidence is like I just said. Society doesn't see Alexee as someone without motive to have harmed baby Alex, especially based on the venue of baby Alex's death. Now, the defense has argued to suppress Alexee's statements based on Miranda, and for that we must understand why Miranda is necessary. Obviously, you have a Fifth Amendment right to not incriminate yourself, but focus in on the word incriminate. And we must ask, did Alexee incriminate herself on the police body cam? Or did she offer the same statement that has been echoed in the defense's filings, on the record, and in international broadcasts by her attorneys? By that I mean Alexee's own statements. Nothing was breathing, nothing was crying, implying a stillborn. That is the same defense that Team Trevizo has been arguing this whole time. Baby Alex is a stillborn. So why on earth are they asking to suppress their exact alibi? The defense doesn't disagree with any of the facts of this case other than baby Alex being born alive. They agree baby Alex was Alexee's baby. They agree she delivered him in the bathroom. They agree she didn't ask for help, and they agree that baby Alex was put in the trash by Alexee. They only disagree that baby Alex was born alive. And this is where I hope that the state hammers this home for the justices. The idea that the suppression and the defense seeking to enter a polygraph contradict each other. You can't have both. You cannot seek to suppress the same exact statements you attempt to re-enter. Now, I know I don't actually have access to the results or the questions of the polygraph examination administered to Alexee, so I don't get to know exactly what was asked yet. But I do know they only get to ask a certain few amount of questions. And I would bet you anything that the questions on that polygraph are: did you see the baby alive? Was the baby alive to you? Was the baby breathing? Was the baby crying? Did you think the baby was alive? I promise you those are the questions. And those are the same statements Alexee is seeking to suppress from the body cam footage. So what are they really trying to do if they want to suppress Alexee's statements, but then reintroduce them? They must be trying to subtract something. There must be some sort of X factor within those statements that they don't want. And that, my friends, I believe, and you're probably well aware of it also, is the third-party statements who was there the entire time, Miss Rosa Rodriguez.
I just asked you, baby, to tell me the truth. I just asked you, baby, to tell me the truth. I just asked you, baby, to tell me the truth.
My friends, it is my opinion, my legal theory, my position, that the defense is attempting to suppress Rosa's statements, not Alexee's. And they're using Miranda and medical privilege incorrectly to suppress otherwise admissible incriminating statements that would have no protections due to not being made by the defendant themselves. Witness statements are not subject to Miranda. Rosa violates medical privilege simply by existing this entire night and not being of any medical necessity. Alexee was a legal adult for over a year at the time of this incident. No privilege should apply. Rosa inherently causes a bunch of issues for the exact protections that the defense is seeking in this case. Rosa's the one who blows up the case. She gives a bunch of information to everybody. But as the defense, you can't stop that. Rosa was there the whole time and has no protections afforded. She's the nail in the coffin for medical privilege. Alexee clearly didn't think that Rosa was necessary for any medical needs, which is what would be needed to be shown by the defense for the medical privilege to continue to apply to Rosa and not break the privilege and allow Rosa to testify about all the medical information. We know this because Alexee's own attorney said that the baby was being born basically immediately after Alexee enters the bathroom and sits on the toilet. By that logic, that would mean at 40 seconds in, when Rosa is walking to the door, attempting to assist Alexee in some way, we would assume the baby is coming out or has already fully exited Alexee's body. And at that time, Alexee denied that Rosa could help her medically in any way, undercutting the idea that Rosa should have medical privilege afforded to her because she has any medical need. Alexee decided Rosa was not of medical necessity, which means no privilege should apply. These are the arguments that I think need to be hammered out in the Supreme Court. The facts of this case undermine the spirit of the privilege and of Miranda extensively. The next issue that Rosa really has is when speaking to the detective later that evening. And he asks about how they got there. Rosa says they came for back pain, giving up medical information immediately, breaking the third-party privilege immediately, showing why third parties never have privilege extended to them, why this is textbook. Now, I would like to present you with my most fair and most cautious argument for both sides. Who said people in the law world are jerks, right? I try and be nice to both sides, despite how I feel. So here's my cards. Read them and weep. Elfine, this is everything. I do not care if, to be extremely cautious of the defendant's rights, that Alexee and Alexee's statements alone in front of police are suppressed. That's fine. You can suppress Alexee's statements alone in front of police. Not before, not after. Those around 3 minutes in the hospital room in front of police. Suppress that. I'm fine. But only statements Alexee made. Any statements she made to her medical providers before or after that should be admissible. This would also include all witness statements, even those made in front of the police, meaning Rosa's, because there are no protection for those statements. The defense has not raised an argument as to why witness statements should be suppressed themselves. The district judge took that upon themselves. The defense asked for an acre and was given miles. There's truly no reason for all this information to be suppressed. You could make an argument that Alexee could have believed she was in custody, which could get you to Miranda for herself. But it would be my position that all relevant medical conversations and witness statements be admissible. Currently, the defense is the one who has everything to lose, and the state is who has everything to gain. So we are not leaving empty-handed as justice for baby Alex. I will tell you that. Now, when it comes to the actual live stream, please let me know if you're interested in having a place hosted here for oral argument. I'll be happy to do that so that we can have a comment section, because I believe there's no way to participate in the conversation on the actual stream from the Supreme Court. So I will be happy to set that up so that we can have a place to converse and talk about, be excited about, everything that's happening in regard to oral argument, because this is a very big day for justice for baby Alex. Quickly on the screen, you will see attorney Robert Alexee, Bob Alexee, of the Karen Reed trial fame. Karen Reed was obviously tried for a second time for murder and was acquitted for that murder charge, found not guilty by a jury of her peers. That is a testament to the attorney's work on that case. All of the attorneys were amazing. But for this particular argument, for the mentality that I'd like us to have going into this, I'd like us to look to Robert Alexee. He's what I would like to call factually passionate. And I think that should be our motto for oral arguments. We want to be factually passionate. You see him on the left, standing strong and confident, holding up a piece of evidence, showing it to the jury. And you see him on the right, again, strong and confident when arguing for a mistrial. And in both of these scenarios, you can only be that strong and confident in the moment, knowing that you are right, knowing that you have every piece of evidence cataloged in your mind, knowing you've studied everything that applies to this case, confident enough to hold up evidence to the jury's face and say, I know I'm right. That is confidence. That is transparency. And that is what Team Trevizo can't do. So with that, we must remind ourselves that we are the Bob Alexees of this oral argument here on the state side. This is our place. This is our time. And justice for baby Alex is right around the corner. Thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe as I'll be covering it all along the way with a legal focus. It's your girl Friday. I'll see you in the next video. Goodbye.